Hi, everyone. Thank you for joining us today. My name is Rebecca Stavish. I'm with MidPenn Legal Services, and I'm here with my colleague, Omeed Firouzi from Philadelphia Legal Assistance. And we're going to be talking with you about worker misclassification. So who is MidPenn and PLA? Basically, we are civil legal aid organizations. We provide free legal advice and assistance for low-income individuals. Some of the areas of law that we focus on are family law, landlord-tenant, and federal taxes. But Omeed and I work in the low-income taxpayer clinics. Who are we and what do we do? Well, an LITC is partially IRS funded. There are approximately 131 clinics across the country. Our goals are to represent and educate taxpayers, especially the low income and ESL folks, and we provide for systemic advocacy. So when there's a problem that affects more than just our clients, we want to advocate and alleviate that problem in the IRS world. And as you can see in the chart on the right, these are some of the topics that we handle when it comes to different tax topics. I know this is probably very confusing for you, but the thing to remember is if your client has an IRS issue, reach out to us and see if it's something that we can help with. Let's jump into being an independent contractor or an employee. So what is worker misclassification? Well, it's when an employer intentionally or otherwise treats an employee as an independent contractor. Typically speaking, an employee is someone who works for wages, is under the control or direction of an employer, and is a part of an employer's business. In contrast, a contractor is someone who is self-employed, who has an independent business, and who is providing a service to another business or individual. Well, what happens when an employer treats the worker as a contractor? Sometimes what happens is the employer does not withhold taxes from the employee's wages. In this case, three things could happen. One, the employer could report the wages to the IRS on a Form 10 NEC or as cash instead of to the Social Security Administration and state and local governments. However, there's another option. They don't report the wages to any taxing authority at all, and this person is paid off the books or under the table. It's not uncommon for employers to pay misclassified employees in cash or by personal or company check. However, even if a person is paid by cash or company or personal check, this does not mean that the employee does not owe self-employment taxes. You still owe self-employment taxes and federal income taxes, even if you are paid cash for your job. And if the worker does not challenge the misclassification, they're going to owe self-employment taxes that are more than what they would pay otherwise if they were categorized as a W-2 employee. So what is involved with the scope of misclassification? Well, in Pennsylvania, the National Employment Law Project found over 580,000 workers are misclassified yearly. That's up to 9% of our workforce in Pennsylvania. Some of the PLA research also includes the various industries where misclassification commonly occurs. That would be in the home health care and domestic work field, construction, and the trucking industry. Misclassification is also a justice issue. This moves the risk and costs from the employers to the workers. It's more likely to happen if the employer believes that a worker cannot or will not complain. So marginalized people are more vulnerable. Economic disparity favors the employer, and the information favors the employers. As much as 10 to 30% of businesses misclassify at least one worker, according to the National Employment Law Project. So, what exactly is an employee in context of the IRS or the Internal Revenue Code? Well, they discuss wages and how somebody is paid in terms of their employment. And then they go on to define employment, which means any service of whatever nature performed by an employee for the person employing him. Kind of confusing, right? Well, thankfully, we've got some examples coming up. There are a lot of different technical exceptions as to what constitutes employment, but the IRS generally defaults to the common law definition of employment. It also involves the degree of control, which can be extended to the employer and the employee. So here's one of the Treasury regulations that goes into details about who is an employee or who is a contractor. I promise you, I'm not going to read everything to you word for word, but this is out here to show you that it's a very, very detailed analysis to figure out who is an employee and who is an employer. But here's a summary of some of the things that the IRS will look at to decide if you are an employee or if you are an independent contractor. And I will tell you that this factor list is 20 different factors. If you want to look at this, some of these are really, really important. And some of them you'll see are things that you might not think of. But think of this. When you go to work, are you using your own tools? Are you using your own machinery? Are you setting your own schedule? Are you able to perform the project on your own time? Or are you supervised and assigned hours and days of when and where to work? This is all very, very important. However, no single factor will make or break the classification. Again, it's 20 different factors, and the IRS will look at all of those factors to determine whether or not you are an employee or an independent contractor. But I want to emphasize this. It's not the employer's decision to make. It's a function of the actual facts and the work relationships. And this is very, very important, just because you sign a waiver stating that you are an independent contractor, it does not mean that the worker is not an employee. You cannot sign away this right to be an employee. So here's another way to look at this and things that aren't so tax technical. You are more likely to be an employee if you have a boss, if you work under supervision, if your supervisor sets your rate of pay and your schedule, if you work full time in an office, factory, or other place of business, if you are using the employer's equipment, if you punch a time clock, if you can be fired or demoted. As a side note, we have different things going on with what we would call side hustles or gig economy. Right now, this is very much under debate. Previously, under the Trump Department of Labor, the National Labor Relations Board viewed gig workers as contractors, but there are signs that the Biden administration will take a different view. As you can see, there are different laws being enacted by the states, and I really want you to look at your own individual state laws if for some reason you're outside of Pennsylvania. This is very important because states will treat gig workers differently, especially when it comes to things like unemployment compensation and workers' compensation. Now, jumping into FICA. This is the Federal Insurance Contribution Act, and it's deducted from your paycheck when you are an employee. So roughly, you're paying half and your employer is paying half. This money goes towards the Social Security tax and the Medicare tax. Self-employed individuals must pay this if they've earned more than $400 for the year. And again, if you are working as an employee, your employer is required to withhold your share of the FICA tax from your wages, but they are also required to pay half of those taxes. So roughly, employees will pay 7.65% of their wages to the FICA tax, and the employers pay another 7.65%. If you're an independent contractor, this actually is paid entirely by you. There's a slight discount in the calculations, but it's a big difference between an independent contractor and an employee. And at the end of the tax year, when you are treated as an employee, you'll receive a W-2. In boxes 2, 4, and 6, you'll see how much tax was actually withheld. This is very important when it comes to future Social Security benefits for you, because you want to be able to demonstrate that you've paid into the Social Security Administration system so that you receive those benefits when you are eligible. And now I'm going to pass this over to my colleague, Omeed.
Thank you so much, Becky. So as Becky mentioned, if you are misclassified, what that really means is that you get a 1099 NEC instead of a W-2, which is what you should be receiving when you are an employee who works for a supervisor who sets your pay schedule and under whom you work under their direction and control. Now, what is a 1099 NEC? A 1099 NEC is really a form meant for self-employed people or independent contractors, people who run their own trade or business. And if you get a 1099 NEC, and by the way, in the past, it would have been a 1099 MISC, where the income is reported as as non-employee compensation. But if you get a form, an income form that reports your income as non-employee compensation, the assumption on the part of the IRS and on the part of tax preparers is that you are self-employed and that therefore you must owe the self-employment tax. Next slide, please. So this is what a 1099 NEC looks like, and you'll see that on line 1 is where typically non-employee compensation is reported. So if you get a 1099 NEC, it's important to figure out whether or not you're really self-employed or an independent contractor, or whether you are actually being misclassified as an independent contractor, and whether it was more appropriate for you to get a W-2 with withholding. Next slide, please. So as I mentioned, if you get a 1099 NEC and you don't challenge your 1099 status, there's a presumption that you are self-employed and that you owe the self-employment tax. And you may end up then, if you don't pay all your taxes on time, being assessed with penalties, because self-employed people have to pay estimated tax payments, much like W-2 employees have to have tax withheld from their pay. It's a quarterly system where you pay as you go. Now, sometimes there are situations where people don't report all of their income, particularly if it's 1099 income, because they may not know what's going on if they get a 1099. You can get hit with penalties for underreporting your income. So it's really important to make sure you report all of your income, but also important to challenge your status if it is an incorrect classification. Next slide, please. So why is this an important issue that cuts across various topics and realms? Well, the fact is that if you are misclassified, you're missing out on key benefits that employees enjoy. For example, employees are entitled to unemployment compensation. Wage and hour laws protect employees, including minimum wage, overtime, Family Medical Leave Act, Employees have the right to collectively bargain and unionize for better wages and working conditions. Employees are also protected under workers' compensation and OSHA and anti-discrimination laws. Next slide, please. These are all benefits, by the way, that are largely not available to independent contractors. And one thing that's really key to know is unemployment compensation is something that often practitioners run into in misclassification issues, because historically employees are the only ones who are eligible for unemployment compensation. In the recent year plus, we've had the CARES Act, where independent contractors did become eligible for pandemic unemployment assistance. But generally speaking, for regular UC, employees are only eligible. However, if you were misclassified as an independent contractor and you really were an employee, you can challenge that through the Department of Labor and Industry. What happens is that you get a 1099, there's no tax withheld, so it doesn't show up as wages on the notice of financial determination. But you basically have 15 days to appeal that, to say, no, really, I was an employee. And they would do an investigation at the Department of Labor and Industry. And if they find out that really you're an employee, you may even have a hearing in this context, then they could make sure that that income counts as wages towards your unemployment compensation. Next slide, please. So as I mentioned, wage and hour laws protect employees. We often have situations where people are not paid time and a half for work that they do over 40 hours a week. And that's something that happens to them in part because they're misclassified, because the employer can claim, oh, well, you're paid on a 1099, you're not really an employee, so I don't have to pay you overtime. Or we've seen situations where the overtime is put on a 1099, whereas the rest of the worker's income is on a W-2. These are cases of wage theft, and these are examples where workers are not paid properly for the work that they've done. And if this happens, it's important to make sure that you file complaints with the federal and state labor departments. Next slide, please. So, it may be that you are thinking about this and thinking, well, what about situations where I have an employee under labor department definition, but not under IRS? It's very rare that such a circumstance would happen. It is true that there are slightly different definitions. The IRS relies on the 20 factors that Becky talked about in the common law overall, but also you got the Labor Department and Fair Labor Standards Act focused on language that relates to suffer or permit to work, and some other issues that go into the definition there. But generally speaking, there's a shared memorandum of understanding. So, if you, since 2011, you've got the Department of Labor and IRS working together to make sure that they coordinate on misclassification and on employment definitions. Next slide, please. So what's important to know is that, as a tax lawyer, I'm biased in saying this, but it's true that there will always be tax consequences of misclassification. Because if you're misclassified and you don't challenge it, you'll end up owing the 15.3% self-employment tax. And even if you do challenge your misclassification, then you still are in a situation where, because tax wasn't withheld, you still owe your share of taxes, your share of Social Security and Medicare tax, federal income tax, state income tax, local wage tax. So it's really important to challenge it so you at least only pay your share and not have to pay double the amount of Social Security and Medicare taxes. Next slide, please. So, if you don't report a 1099, of course, there are lots of negative repercussions, because you may get audited. You wouldn't get Social Security credit for the money because there's no tax withheld. And also, I should note here that one form of misclassification that Becky touched on is being paid in cash. If you have been paid in cash income, you must report this cash income. But if you're paid in cash and no tax is taken out and there's no form filed with the IRS or the Social Security Administration, that is a form of misclassification. You're being classified as nothing, basically. So it's important to get it on the books for Social Security and make sure that you're paid properly. Next slide, please. So here's a good example that people can use that I think is useful. So in my hometown of Scranton, Pennsylvania, Michael has hired Dwight as assistant to the regional manager. Now, Michael is Dwight's boss, and he sets Dwight's pay and schedule and assigns him tasks. Sounds like an employer-employee relationship. But when it comes time to file his taxes, Michael issues Dwight a Form 1099 NEC that reports $10,000 of income. Now, because Dwight got this 1099, he owes the 15.3% self-employment tax, both the employer and employee side of Social Security and Medicare taxes. That means that if he doesn't claim any expenses, he'll owe $1,413 in self-employment tax. Now, I should note that's 15.3% of 92.35% of his 1099 income. The 92.35% is just because they give you a little bit of a break there in terms of calculating the self-employment tax. That's a lot of money. Now, if Dwight challenges his misclassification and says, Michael, how could you? I thought I was an employee. If he files a form with the IRS, which we're going to get into in just a minute, to say, actually, I was an employee, I should only have to pay my employee share of tax, then he would only owe the employee share of Social Security and Medicare tax. So that's 7.65% of that $10,000 in compensation. So that's $765, or roughly half of what he would otherwise owe. Next slide, please. So it's important to know that often employers will try to sell misclassification to their workers. They'll try and say, oh, it's a training period, or you have more flexibility or independence, even though that's not necessarily the case. And the fact is that there's nothing in labor law that requires employers to have workers work absolutely 40 hours a week, or else they're independent contractors. That's not the case. And also, the fact is that if you are misclassified, sometimes workers, the employer will say to them, oh, well, you get more in pay, you don't have to take tax out. And so sometimes people, they may know that they have to pay taxes down the road, but it seems like an attractive offer at first. Or, there's the case that you can claim expenses. Employees can no longer claim expenses after the Tax Cuts and Jobs Act, but independent contractors can. So these are some ways that employers try to convince workers that misclassification might be beneficial to them. Next slide, please. But, that gets to how there is a big disparity in bargaining power here, because employers are often, employees, workers are often afraid of reporting their misclassification because there's a fear of retaliation. And we'll get into that more. And they may not want to cause problems for their employer. But the next slide gets into how the biggest reason is they don't know they can challenge it. And so the next slide talks about how do you challenge your misclassification and why is it important to do it so you can pay only your fair share of tax. It's a key pillar of the Taxpayer Bill of Rights, to make sure you get all of your Social Security credit on the books, and to hold employers accountable. We've had clients who've said that after they challenged their misclassification, they had more, they had their employers later on down the road actually change their practices so that they could W-2 employees instead of continuing to 1099 them wrongfully. So by challenging your misclassification, we can ensure that you only pay your correct share of tax, and that way you can, on your tax return, account for that. Now, I should note, by the way, if you get a W-2 and a 1099 from the same employer for the same year, and there's no real distinction in the income, then the 1099, you don't need to file an SSA in that circumstance. The 1099 income goes on what's called a Form 8919, where you account for just your employee share of Social Security and Medicare tax on that 8919. But that gets to the broader question here in terms of the next slide, which is that the main primary way by which you can challenge your misclassification for tax purposes is to file what's called a Form SS8 with the IRS. And this is the form you file to figure out whether you're an employee or an independent contractor. But crucially, by challenging your misclassification by filing an SS8, just the filing of this form gives the taxpayer the right to list their 1099 or cash income as wages on their tax return and attach a form 8919. It's a form 8919. It gives them the right to attach that form to their return on which they would account for their share of Social Security and Medicare tax on that form. So they only pay 7.65% instead of 15.3%. Now, what is the SSA? Really, it's a packet that asks questions related to those 20 factors that Becky talked about. That get to what are the key factors of control that showed that there was external control over you in your job, that there was supervision, that you did work under the direction and control of another person or entity who at least even had the right to control your work. Now, the next slide talks about some of the specific sections of it and when it should be filed. So it should be filed when you're ready to do so, because the fact of the matter is that unfortunately it's not a confidential form. So your employer will find out that you filed it. In fact, the employer gets sent a blank SS8 and they have to basically respond with their version of the facts. Now, the next slide talks about how the SS8 should be filed, when you're absolutely ready, and it can be filed at different times. I should note, by the way, that though your employer finds out, if they, God forbid, retaliate against you, there is an anti-retaliation provision of a federal law called the Taxpayer First Act that goes into how there is a cause of action if your employer were to take action against you, if you were to file an administrative claim against them for not paying the correct amount of tax. Now, you can file an SS8 while you're still working for an employer. If the IRS determines that you're an employee, then ideally what will happen is that they'll start to W-2 you. But it's true that there are safe harbor provisions that allow employers to continue to 1099 people, even when the SS8 unit has determined that you are in fact an employee. But that still doesn't change the fact that you still only have the right to pay your correct share of tax if you're determined to be an employee. Next slide, please. So, just before I get into this a little bit, I just want to make sure that people understand the SS8 form. Basically, that asks, why do you believe you're an employee? It asks about supervision that you had in your job, whether there were any required reports, whether you had to sign a non-compete, what a typical day looked like, who set your schedule, who set your pay, were you entitled to any benefits of the job, was there any furnishing of tools or materials, were you required to work full time? All questions that get to, were you really working under the control of another person such that you really were an employee? And you got to make sure you fill it out completely, even if there's something that's not applicable, put NA. Now, when should the SS8 be filed? There are several administrative postures that are important. You could file it before you file your tax return anew, thus making sure you report the income as wages on your return. You can also file it to get a refund of the employer's share of tax that you may have already paid through the self-employment tax, or you might file it years after the fact to reduce a tax debt that you have, so that you can make sure that there's less debt on the books. Now, one thing that's really key to know here is that though there's no time limit to reduce a unpaid tax debt, there are time limits for claiming a refund. So let's say you were misclassified in 2018 and you paid the self-employment tax on your 2018 tax return. So the 2018 tax return, that was due on April 15th of 2019. So you have 3 years from then, April 15th, 2022, to claim a refund of the employer share of tax that you shouldn't have paid. But you should first file an SS8 and then do an amended return before 4/15/22 to do that. There's also 2 years from when a payment was made to try to recoup a payment. So if you owe for like 2013, then you made a payment that was on, let's say, December of 2019, then you have 2 years from then, December 2021, to get that payment back if it was a payment towards debt you had from misclassification, let's say. So the next slide goes a little bit into this, and we had a client actually who was affected by this 2017 example, so we made sure to get it in before then, the SS8 and the amended return, so she could get back a little bit of money from employer share of Social Security and Medicare tax that she had paid. Next slide, please. So, you might be wondering what happens then, after I file the SS8. Well, you'll get a determination after some time in which the SS8 unit will determine whether you're an employee or an independent contractor, or they might send you an advisory saying as much, basically. If the employer responded, then the SS8 unit will give you an analysis based upon your responses and the employee's responses, and will compare that against the law and the facts to determine a thorough analysis of your situation. And if you're determined to be an employee, then you can use that to file your return if you haven't already done so. But it also means the employer is potentially liable for their share of taxes at least. But the fact is that they have certain safe harbors here that they can take advantage of. But again, if you're determined to be an employee, that is determinative of your status. Next slide, please. So, if they say you're an independent contractor, which we actually haven't seen yet that happen in our office, though you don't have a right to appeal, you can ask for a reconsideration of that request. Next slide, please. So, there are other ways that you may find yourself litigating the misclassification issue. But in terms of taxes, the SS8 is the main way that you want to do it. And even if you find yourself in tax court or in what's called a collection due process hearing in front of an IRS officer, you still got to probably file that SS8. Next slide, please. So there is a federal law, it's part of the tax code, section 7434. It says that if an employer fraudulently files a 1099, you can get damages against them. This applies to cases really where there's over-reporting of income. It may apply to pure misclassification. The courts are split on this. No circuit court has actually ruled on it, but there have been various district court rulings. So the jury is still out on this one. Next slide, please. Now, you can file a whistleblower form with the IRS to report an employer for not paying the correct share of tax, and maybe you'll get some reward from that. Next slide, please. There's also a one-page, totally confidential 3949A information referral form. But again, the main thing is the SS8 is the way that you really want to go in terms of disputing your 1099 status. Next slide, please. So, as I mentioned, there's an anti-retaliation provision of the Taxpayer First Act that might protect workers who challenge their status and unfortunately would be victims of employer retaliation. But the fact is that our office at least, we can represent you in such cases if that were to occur. Now, what's also true, by the way, is that when you're misclassified, the employer is on the hook for the employee share of tax as well. Technically, the IRS is always going to go after the taxpayer, the worker themselves, because you always at least owe your share of tax. But both the employer and the employee are liable for income and FICA tax that wasn't withheld if the employer did it willfully. So, the thing is that you may want to raise that as a potential point in a collections case, but we've had some interesting results with that. But the fact is that you're always going to at least be liable for your share. So there's no argument that you yourself are liable for your share of tax. Next slide, please. So our office is available. MidPenn Legal Services is available. Our tax units are there to assist you if you were misclassified as an independent contractor and you need help in challenging your misclassification. There's also the Taxpayer Advocate Service, which is an independent branch of the IRS that helps taxpayers resolve issues that they're having with the IRS. So I hope that you would seek our assistance if you need help with this. This is an increasingly salient issue that people are talking about and that is in the news. Make sure too that if you are misclassified, you can also file forms with the U.S. Labor Department, the state Labor Department, to make sure that you are challenging it, because this is a labor and employment issue as well. And so you might, there might be fines or penalties that the employers are subject to then, depending on the jurisdiction. So, we want to thank you all for joining us today. Our phone numbers are up here: MidPenn Legal Services, 844-MPLS-TAX. Philadelphia Legal Assistance, 215-981-3800. Let me also put in the chat on Facebook the link to that page on worker misclassification that is in that slide there. So that you all have it. So if you have any questions, let us know. Thank you so much. I think I'll hand it over to Becky now.
Thank you, Omeed. That was wonderful. As you guys know, there's lots of information. We did record this, so feel free to watch it again if you missed something. Also, feel free to reach out to us with questions. But now is a good time for questions if anyone has any.
Okay, I'm not seeing any questions in the chat or on Facebook.
Okay, great. All right, we'll give you just another moment and then we'll wrap things up. But as Omeed said, if you do have questions and you think that you are someone who has been misclassified as a worker, or you are a social service provider and you want to work with us to help people that you serve to alleviate this problem, please reach out to us. Our phone numbers are 844-MPLS-TAX and 215-981-3800. And on a side note, be sure you check out that website from Philadelphia Legal Assistance. It's got a great number of resources. Omeed has some very wonderful information that he's gathered and assembled for that site. And it's truly, truly very helpful. And I hope that it can help at least someone out there.
Okay, thank you very much and have a great day. We're
Thank you,
ending the
guys.
webinar.
Thank you, everyone. Have a good day. Bye.
Bye.